Hi, I'm Attorney Marshall Hong from ImmigrationInfoSite.com. In this short video presentation entitled Anatomy of a Removal Proceeding, I'll be giving an overview of the various stages of a removal or deportation case in immigration court. This video presentation is not intended as a substitute for customized legal advice from a qualified immigration attorney. Instead, it is intended only to give a brief and general overview of the various stages of a removal proceeding to help you better understand the proceeding. A removal proceeding, also known as a deportation proceeding, is a case held in the immigration court in which the U.S. Department of Homeland Security, Immigration and Customs Enforcement Agency, asks an immigration judge to deport a non-U.S. citizen from the United States. The government can ask that an individual be deported for a number of reasons, including overstay of an immigration visa, certain criminal convictions, violations of immigration law, or a prior deportation order against that individual. A removal proceeding is initiated when the government files a document with the immigration court called a notice to appear. A notice to appear is a document charging that an immigrant is removable on one of the various grounds of removability. Now let's take a brief look at the parties involved in a removal proceeding. First is the respondent. The respondent is the non-U.S. citizen who is facing the deportation on one or more grounds of inadmissibility or deportability. The respondent may appear in immigration court either pro se, meaning on his own behalf, or he may appear represented by a counsel or attorney of his choice. The government will also have an attorney representing the Department of Homeland Security. This is the trial attorney from the Office of the Chief Counsel. The role of the Chief Counsel is that of a prosecutor. In other words, they're the ones asking the immigration judge to deport the respondent from the United States. Finally, there's the immigration judge. Now, the immigration judge is appointed by the U.S. Department of Justice, Executive Office of Immigration Review. The role of the judge is to consider all of the evidence and testimony and make two determinations. First, is the respondent removable or deportable? And second, if the respondent is found to be removable, the judge will next determine whether or not the respondent is eligible for any form of relief from removal. In addition to the respondent's attorney, the government's attorney, and the immigration judge, there may be other individuals present in the courtroom during a removal proceeding. There may be the judge's clerk, whose role is to maintain the records of the court and the court's schedule. There may be an interpreter to translate between the language in which the respondent is most comfortable or most fluent and English. And there may be witnesses either appearing on behalf of the respondent or on behalf of the government. Generally speaking, there are two types of hearings at which the respondent will appear during the course of removal proceedings. The first type of hearing is known as a master calendar hearing, and this usually includes the first appearance at which the respondent appears before an immigration judge. A master calendar hearing is a preliminary hearing at which such matters as scheduling, the taking of pleadings, which I'll discuss more in detail later, and scheduling occur at master calendar hearings. On the date of a master calendar hearing, there are likely to be a number of other respondents also appearing before the immigration judge for their master calendar hearing. The other type of hearing is known as an individual calendar, also known as a merits hearing, or in more common language, the trial. At the individual calendar, The judge will hear all of the evidence and witness testimony presented by both the respondent and the government's attorneys, and at the conclusion of the individual hearing, the immigration judge will make a determination as to whether the respondent will be deported or whether the respondent will be allowed to remain in the United States for having been granted one of the various forms of relief from removal. Another type of hearing at which a respondent may need to appear before an immigration judge, but not in all cases, is a bond hearing. This is also known as a hearing for custody redetermination. When the respondent is in the custody of Immigration and Customs Enforcement, also known as ICE, ICE will have made an initial determination as to whether the respondent may be released on bond, and if so, the amount for the bond to be posted. If the respondent disagrees with ICE's determination, the respondent may request the immigration judge to review that determination and either allow the respondent to post a bond for his release or to lower the bond amount as set by ICE. At the initial master calendar hearing, the immigration judge will ask the respondent for certain information. First, the immigration judge will verify the respondent's name, address, and phone number. The immigration judge will also ask the respondent whether he is fluent in the English language, and if he is not fluent in English, the immigration judge will determine what is the respondent's native language or language in which the respondent is most comfortable, so that the immigration judge can order an interpreter for the next hearing date. If the respondent appears with an attorney, the immigration judge will ask the respondent to confirm that this is the attorney of his choosing and whether or not he would like to have that attorney represent him for the remainder of the proceedings. The immigration judge will then ask the respondent whether he received a copy of the notice to appear. And if he has received a copy of the notice to appear, he will ask the respondent, through his counsel, if counsel is present, to enter pleadings. What this means is that the respondent must either admit or deny each of the factual allegations contained in the notice to appear, and also the respondent must either concede or deny the charge of removability. If the respondent admits or concedes that he is deportable or removable, the immigration judge will then ask what relief, if any, the respondent will seek. If the immigration judge determines that the respondent is eligible for some type of relief, then the immigration judge will set a date for an individual calendar at which the immigration judge will consider the respondent's application for relief and make a determination as to whether or not to grant that request for relief. If the respondent denies that he is removable, either because he denies one or more of the factual allegations contained in the notice to appear, or if he admits all of the factual allegations but denies that those allegations make him deportable, then the government's attorney must convince the immigration judge that the respondent is in fact removable. If the government's attorney cannot convince the immigration judge that the respondent is removable, then the removal proceedings will be terminated and the respondent will not be deported from the United States. On the other hand, if the government's attorney is able to convince the immigration judge that the respondent is removable, the immigration judge can then still move on to the question of relief from removal. In other words, even though the respondent has been found to be removable, if he is eligible for some form of relief from removal, the immigration judge can still allow him to remain in the United States and not be deported.